So good evening, all. My presentation tonight is based on research rather than on my personal experience as a lawyer. Land use isn't my legal specialty. But I was married to a land use attorney for 30 years, and I think that counts for something. At least I was familiar with the acronyms. My primary source of information has been the work of Portland land use attorney Fritz Paulus, especially his 2015 report, Oregon Conservation Easement Assessment Project. He prepared this very informative report on behalf of a number of nonprofits, including the Coalition of Oregon Land Trusts, known as COLT, and our own Clackamas SWCD, among others. When I interviewed Fritz, I asked if the report is still accurate after 6 years, and he said, nothing has changed. So let me recommend it to you. You can find the report on the COLT website under General Resources. I'll also lean heavily, on the Oregon State Bar's Real Estate Desk Book, Chapter 59, which Fritz also wrote. Sorry while I get used to this slide presentation. And my third primary resource is, now we look at it, the Working Lands Guidebook, which was just published last Thursday by the Oregon Association of Conservation Districts, OACD. I was so excited when they published this right in time for my presentation. And I got a copy of it, used it in this presentation, and then sent a copy to Cheryl, who says it's already on our CRBC website and you can take a look at it. And I recommend it to you. The guidebook focuses more on conservation acquisitions than on conservation easements, but the processes involved are similar, and the funding sources as well. And there's a chapter devoted to conservation easements. As the title suggests, the OACD guidebook focuses on working lands as distinct from natural lands, but it recognizes that the two often overlap and easements for natural and working lands can coexist on a single property. In my presentation tonight, I'll generally use the term natural resource lands indiscriminately. Conservation easements are a modern land use instrument, unlike traditional easements such as rights of way, which came to America with the Mayflower. Conservation easements came into being with the environmental movement in the 1970s and grew exponentially in popularity after the federal government offered a tax incentive program granting tax credits to landowners who would create them. By 2014, there were over 100,000 recorded conservation easements in the US, protecting over 22 million acres on private and public lands. The popularity of conservation easements in most states other than Oregon resulted from two things. First, in most states, they were virtually the only tool available to protect natural resource lands from development. And second, landowners were able to make significant money through the federal incentive program. Some landowners realized this windfall legitimately through credits they applied against their own income tax obligations. But many others fell under the influence of investment syndicates that offered rural landowners a windfall if they'd sell their easements and rights to the tax break to a syndicate. The problem with the tax break incentive was that many rural landowners didn't make enough income to benefit from a tax credit, whereas the syndicate was backed by wealthy investors who could use the write-off to decrease their substantial income tax obligations. The syndicate paid landowners cash for the easement, then donated the easement to a charitable land trust to serve as easement holder. The amount they paid the landowner was, of course, only a modest percentage of the total tax credit, but it was more than the rural landowner thought they'd ever get off the land, either by selling or working it, since the land was mostly riparian areas, or wetlands. Unfortunately, the syndicates also inflated the value of the easements using unscrupulous appraisers. It was years before the IRS realized they were being scammed. But to this day, the IRS scrutinizes applications for tax credits based on conservation easements, and I understand only a handful of appraisers in Oregon are willing to fill out the paperwork, take care of the presentation to the IRS. I also learned that any applications for a tax credit based on an easement owned by more than one taxpayer sends up a red flag for the IRS. Even though the landowners may just be neighbors trying to use economies of scale to get a single conservation easement in place for their adjacent lands, the IRS automatically suspects syndicate tax scam. Meanwhile, in Oregon, while the rest of the country was booming with conservation easements, by 2014, Oregon had fewer conservation easements than all but 10 other states. 43 conservation easements in Oregon protected just 192,306 acres. In contrast with California, who had 2,860 conservation easements protecting 1.5 million acres. Minnesota ranked #1 in the US with more than 12,000 easements. What was going on? Oregon's always had a reputation for environmental leadership. Why not here? You probably guessed. Turns out the reason Oregon had so many fewer conservation easements than other states, and still does, is that about the same time the federal conservation easement statutes were enacted, Oregon passed its groundbreaking land use laws. These laws protected Oregon's natural resource lands on a massive statewide scale, in contrast with other states who were protecting lands piecemeal through conservation easements. By 2015, despite having fewer conservation easements than 40 other states, Oregon had protected 27 million acres of privately owned farm and forest land through its land use laws. The closest any state came to that level of protection was Maine, with easements protecting about 2,300,000 acres. There are two reasons why fewer landowners establish conservation easements in Oregon. First, conservation-minded landowners were satisfied that their rural land was adequately protected against development by our land use laws. And second, the tax incentive calculations simply didn't pencil out for most Oregon landowners. The federal tax credit is based on the fair market value of the easement, which is calculated by subtracting the value of the land after the easement from its value before the easement. If Oregon laws already prohibited development or harvest on the easement, there was no loss involved in donating the easement to a charitable nonprofit. From the IRS's point of view, there was no charitable donation, and therefore no basis for a tax credit. If a quick and easy tax write-off was the only incentive for conservation easements in Oregon, there would be no reason for us to devote time to studying them tonight. But fortunately, as Paulus points out in his 2015 assessment, there are other legitimate ways to provide a financial return for participating landowners. And there are other considerations that make conservation easements attractive for owners of working and natural lands, including genuine concern among a growing number of rural landowners for the future of our state's natural systems: clean water, clean air, food sources close to our urban areas, not to mention concern for the planet itself. As population growth and climate issues put pressure on the foundation of our land use laws, conservation easements may be an increasingly effective backup system for ensuring that our precious natural resource lands are protected. So with that in mind, let's take a look at the Oregon statute authorizing conservation easements so we can better understand how we might use this tool. According to Oregon's authorizing statute, a conservation easement is a legal agreement between a landowner and an eligible organization. The agreement imposes restrictions on the landowner and affirmative obligations on the easement holder to ensure the easement fulfills the purposes required under the statute. The purposes of a conservation easement are set forth in the statute. They include retaining or protecting natural lands, scenic or open space values of real property, ensuring its availability for agricultural, forest, recreational, or open space use, protecting natural resources, maintaining or enhancing air or water quality, or preserving the historical, architectural, archaeological, or cultural aspects of real property. As with traditional easements, a conservation easement doesn't transfer title to the property. It grants a right of use. After the easement is in effect, a landowner still owns the land and can sell it or bequeath it. However, the terms of the easement agreement are binding on the landowner's successors and assigns. In property law, that's called running with the land. A conservation easement runs with the land. Whoever owns the land is also bound by the conditions of the conservation easement agreement. The statute also says conservation easements will be unlimited in duration, which is to say they are in perpetuity, unless the agreement says otherwise, which the landowner may choose. As to what perpetuity actually means in practice, I've read that the perpetuity promised by conservation easements might better be called perpetuity light, because the law provides that certain parties may challenge conservation easements or amend or terminate them. Because there is the possibility of future litigation, easement holders may secure conservation easement insurance, or they may set up an endowment fund to cover future legal expenses. It's also comforting to know that Oregon's courts are inclined to give deference to conservation easements because they're considered to be in the public interest. The principal parties to the conservation easement agreement are the landowner, also called the grantor, and the easement holder, known as the grantee. The federal conservation easement statute generalizes as to who may serve as an easement holder, but the Oregon statute lists exactly who is eligible to serve. Eligible holders listed in the statute can be divided into three categories: government entities, charitable or nonprofit entities, and Indian tribes. Government entities that may hold conservation easements are specifically identified. They are the state, meaning the state of Oregon, metropolitan service districts, soil and water conservation districts, city park and recreation districts, and county service districts providing sewage and stormwater services in Clackamas and Washington counties. Pretty specific. Interestingly and importantly, Oregon statute does not list the US government as an eligible easement holder. Inconveniently, that eliminates the US Fish and Wildlife Service, BLM, and other federal entities from serving unless they do so in cooperation with one of the qualified entities. The highlighted language on my slide, which casually mentions in cooperation with any federal or state agency, is the only authority we have to link a conservation easement to the deep pockets of a federal agency or program. But this interpretation of the statute in Oregon has been litigated, and it's agreed. Oops. I'll find my slide eventually. It's agreed that federal entities can serve as holders as long as they do so in cooperation with other enumerated entities. There we go. I'll get my hand away from the mouse. Charitable entities may serve as holders if their purposes align with those of the conservation easement. And those purposes would be in the founding documents of the charitable entity. For example, a church could not be an easement holder because its purpose does not align with the statute. Indian tribes may also serve as easement holders if they are recognized by the Department of the Interior or listed in one of two termination acts, as well as have their traditional cultural area in Oregon. There are two recognized tribes with geographic and cultural ties to the Clackamas Basin, the Confederated Tribes Warm Springs and Confederated Tribes of Grand Ronde. When I first learned that the big well-known land trusts are currently limiting their involvement in conservation easements to those of 200 acres or more, it occurred to me that we might approach one of the tribes as an easement holder. The Grand Ronde in particular might see a connection between its efforts at Willamette Falls and protections for the Clackamas Basin. Securing an easement holder is an important first step in the conservation easement process. The most sought after holders are the well-established land trusts because of their experience and know-how in dealing with conservation easements. The Coalition of Oregon Land Trusts, COLT, can help landowners find an appropriate easement holder. COLT is a nonprofit association of Oregon land trusts and serves as a statewide service center in the land trust community. The role of the easement holder is extremely important. During startup, holders may take the lead negotiating with landowners to identify what the terms of the easement will be, getting the land surveyed and appraised, consulting with tax professionals, even finding and applying for grants to compensate the landowner and cover expenses. Earlier, we recognized that compensation to landowners for donating easements may not be the windfall some landowners hope or expect, but there are some circumstances where the easement's value may be enhanced by considering other factors that may not come to light in a traditional appraisal. An experienced holder can help identify such opportunities. For example, an easement may be appraised as more valuable if it's in a working forest and it requires the landowner to reduce harvest levels, or if the easement imposes stricter ecologically based management requirements, or requires larger riparian buffers than are mandated in the Oregon Forest Plan. An easement may also have added value if it has a Measure 49 entitlement and the landowner agrees to forego that entitlement. To the extent the landowner forgoes revenue opportunities by creating a conservation easement, the amount foregone may legitimately be considered a charitable donation for income tax purposes if it's presented to the IRS with sufficient documentary evidence. Another financial incentive available to landowners is a special property tax assessment for conservation easements, like those available for farm or forest land.
At least for a little bit before she breathes again.
The effect is to lower property taxes on lands encumbered by a conservation easement. Other incentive programs are available through federal agencies, such as the Agricultural Conservation Easement Program, ACEP, which funds 50% of the value of an easement that protects wetlands through its Wetland Reserve Program. And then there's BPA's ongoing mitigation obligation for operation of the federal Columbia River Power System. And there's the Community Forest Program of the US Forest Service, which in our own basin provided 50% of the funding for the acquisition of the Eagle Creek Community Forest by Clackamas SWCD. According to Jan Lee of the Association of Conservation Districts, the Trust for Public Lands was extremely helpful to the Clackamas SWCD in that project. Other potential funding sources are the Oregon-based programs such as OWEB. At the time of the Paulus Report 2015, Oregon had spent $6 million purchasing 20 conservation easements. Another funding source from the state, of course, is the Soil and Water Conservation District. SWCDs, as I mentioned, are specifically listed as eligible conservation easement holders. But according to Jan Lee, Executive Director of OACD, only a few SWCDs are currently serving as easement holders. One of those who is serving is the Clackamas SWCD. Remember that the community forest was a conservation acquisition, but the Clackamas SWCD has an actual conservation easement, and that is at Camp Adams, which is in the Molalla watershed. I was curious to know how many SWCDs were participating in easement conservation programs. There were only 3, and Clackamas's SWCD has only 1. They've had it for 3 years, and I wondered if the SWCD was pleased with the program and whether they were considering broadening the program. Jan said that SWCD is very pleased with their Camp Adams program, as well as with the community forest. And at their conference last week, there was considerable discussion, actually a half day, devoted to discussing what they were going to do about expanding their conservation easement program. The Clackamas SWCD gets about 3 to 4 requests to serve as the holder of conservation easements a year. At this time, they are considering any of the applications, but they are going to meet and talk about expanding their strategic plan to focus on conservation easements in the coming years. And that, my friends, is where I'd like to stop. Like the salmon stop at this waterfall on Rock Creek, which is right at the end of my block. And I'd like to ask if you have any questions, either based on what I've told you or what I didn't tell you, just because I ran out of steam. So please formulate your questions and let's take a little time. And if you don't have questions, and if you'd like, we could stay on and talk about conservation easements and how we might use them in our watershed.
Yes, I'm wondering if Maddie could present, not only like you recorded it, but if we could have a PDF of your presentation. I thought it was very well put together and organized. So, you know, you send out to us if we requested or something. I think it'd be very helpful.
Can I send it? Can I send it with the drawings that my granddaughter, the little happy, cheerful, you can do it, grandma pictures that she included on my my copy?
That should be the title page. Yeah. And the other thing I just wanted to mention is that I was just looking at some statistics for forest land published by Oregon Forest Resources Institute. And the reason why I think this is important is that according to this, and this is probably a lower bound for our county, but 75% of landholders of forest lands in Oregon only own from 10 to 49 acres. So your point about the 200-acre threshold is important because, you know, there's a lot of valuable land that folks own that's smaller than that. And I bet we have 80 to 90%, you know, in the county that own that small amount of parcels. And so if we can get those folks interested in something like this, it might go a long way to preserving some special places in our county.
Just remember, you can't amalgamate them. They have to come, each one has to have its own easement.
Mhm.
But if the potential holders get more comfortable, you know, SWCDs in all the years, it's been since the 1970s that Oregon's had the conservation easement opportunities, and only 3 SWCDs have taken advantage of that program, have been willing to serve as holders. They were just uneasy, I suppose, about serving as holders. And now they're gaining a little more courage and seeing how valuable they may be for just that reason, Dave. So I think they may be, well, especially, I'm thinking, what's the role of the Watershed Council? It could be to provide additional services to the SWCD so they're not going it alone. Somehow we can provide some supportive role so that they don't feel like they're out there alone managing all of these small forests. I don't know, we'll have to think about that.
The other thing too is that the CR Basin Councils could provide a valuable informational pathway for folks. I mean, because we, with the Shade Our Stream program and whatnot, we have a database of folks that we may come across and they say, wow, this place really should be looked into, for further protections if the landowner is interested. And they may not even know. And so this would be a good way for that connection to occur.
Mm-hmm. Hey, Maddie, I was wondering, I've heard in the past that a lot of organizations are hesitant to take that role of being the holder of a conservation easement. So it's really encouraging to hear that the SWCDs are talking about how to do it and wanting to do that a little bit, or willing to do it a little more. But I was wondering that because I've always heard in the past how hesitant people are, what are the obligations or risks that might come along with being the holder of a conservation easement?
I don't know what all they are, but it is a huge role after they get started. They do have to have this insurance against legal challenge is only available to the land trust, as far as I know. It's definitely not available to SWCDs.
Okay.
And I don't think it's available to OWEB either, but not to SWCDs. So what they did with the Camp Adams easement is, I think they got a donation to serve as an endowment that would be specifically to gain interest and be there in case someone challenges the easement at some point in the future.
Okay.
So that's one of the problems.
Mm-hmm.
The other thing is that perpetuity element. Cheryl asked me whether CRBC could be a holder, and I thought, could we be a holder? So I read the statute, and according to my reading of the statute, we could be a holder. We're a 501c3. We have, our purposes are as set forth, I think, in the statute. But then I was parsing the statute with someone from OWEB, and they were trying to show me that, no, you have to have in your formation documents the purpose that you are going to acquire land. One of your purposes has to be acquire land. Well, I don't read it that way at all. I think that was a torturous reading of that statute, but they said OWEB would probably not give us money if that wasn't in our founding statement. But he said, if we wanted to do it, which I said I would never advise that we do, but if we wanted to do it, we could change our bylaws to say we could hold land, so that we could be, if we wanted to change our bylaws, say that we were going to acquire, in fact, we would say specifically, we're going to acquire conservation easements if we felt we could do it. And if we felt that the Watershed Council program was going to be in perpetuity. The SWCDs, at least some of them, many of them maybe, have a tax base now. So the possibility, the likelihood that they're going to be in perpetuity is greater than watershed councils, which are dependent on OWEB, which are dependent on a governor who likes who likes fishing. We're lucky to still be alive at this point. So that's what I discovered so far. So we'd have to look at the foundational documents for the easements, conservation easements, to see what all is involved. I looked at a few templates that are available through Colt on their website, and I saw there's an enormous number of documents involved, legal documents, in setting up an easement. Mm-hmm. And each one is different depending, when you talk about monitoring it in perpetuity, what system would you set up to monitor it in perpetuity? And of course, it depends what kind of easement it is, what kind of monitoring it would require. And as SWCD has found out, it's not so scary if it's a church camp. You know, it's pretty well protected. You know, they have not felt they were nervous about it, I'm sure, but they haven't felt the stress in the actuality.
Maddie,
So,
Maddie, I have
Yeah.
a question.
uh-huh.
What if the CRBC was at risk of dissolving or disappearing at some point, but we also decided to change our bylaws, our founding documents to allow us to acquire land? What if we designated a successor in interest, like the SWCD or something like that, to protect forever the easement?
I think that's what we would do. That's exactly what we would do. Or as we do in estate law, you know, if the charitable entity you're leaving something to is no longer exists at the time you die, then you want your trustee to give that to one that fulfills a similar mission, has similar purposes. And that's what we try to do. We would make it as safe as possible, as perpetual as we can possibly make it, given the way life is. Mhm. Any other
Any-
thoughts?
I have a question.
Go ahead.
Oh.
Go ahead.
I was just wondering if we were to talk to landowners about this concept, what would be a motivating factor for them aside from just doing a good thing and protecting the land?
Well, there are financial opportunities. There's the property tax. If they aren't already taking the forest or farm assessment program benefit. And it could be that they would be able to get the tax credit. And then I think the big one is that there are funds available to encourage landowners. They're available through some of those federal and state programs that I mentioned. In the Working Lands Guidebook that was just published is a whole list of possible funding sources, these nonprofits that are associated with the land, that they're through the Department of Agriculture or the Department of the Interior, and they will pay money to landowners to put their property in easements. There would be grants that would be applied for. That's another job of the easement holder, finding that compensation for landowners. So there are these programs we'd apply for on behalf of the owner of the potential easement. Are we still there?
Yeah, I think Riz had a question as well.
Mhm.
Well, I think maybe pretty much answered it, and I can look further without having to bring it up here. To my knowledge, there's Western Rivers Conservancy has conservation easement across the river downstream, family long time logging operation. They protected that. And there's a piece next to me that's owned by Cal Farms of the family, for Calcano family. There's a kind of a significant piece of land. It's very small. It's not farmed, but it's significant for several good reasons. I've made kind of lightweight approaches to Metro and others about doing this, but doing something like this conservation. But like I said, I think that, you know, a bunch of questions I had about it before, you've answered very well tonight. Thank you.
Oh, you're welcome. I'm so glad it was helpful to you.
And the other thing too, I think, from my standpoint, is that as we go about, you know, we talk about the water temperature, and as areas get determined to have cold water sources, refugia, what have you, this could be a strategic or even, I say, tactical way for us to approach a landowner and say, you know, you don't need to have your whole property in a conservation easement. We could just reserve a portion of it that was deemed in the public interest to be, a precious event. I mean, as climate change becomes more severe, areas like this are going to be more sought after. And so I think that would be certainly a very, something to study.
I agree with you, Dave. I think this might be a good time to approach landowners and to explain that, the good that they would be doing, the fact that their land would not be less valuable with these easements. One of the problems, well, that's a major thing, that they still have so much control, complete control over their land. And it could even look at the easement as being a benefit of their property, a positive feature, like on your property, the work that you've done.
All right. Any further questions for Maddie or comments or discussion?
Liz, did I answer your
Yeah.
question?
Yeah, very well. Thank you.
Okay.
I was typing. This is a little bit of a digression, but I know that there are tools being developed now that should probably be coming out in the next few years for forested landowners of any size of property to be able to enter their property into like a carbon tax credit program that would with it would come a conservation easement as well with certain prescriptions. And so I think that's going to be a tool that's any forested landowner will be able to apply for, I think in a few years.
Oh, sooner the better. I kept looking for something like that. There wasn't.
Mm-hmm.
I'm really glad to hear that there's something afoot.
What organization or department is working on that, Liz? Do you know?
Well, it's my husband's company. And they're working through the California carbon tax program, and they're developing a nationwide tool. They're kind of rolling it out state by state. Their company is called Finite Carbon, and they're going to have an online portal where you can just easily apply.
All right, we'll have to keep our eyes
Eventually.
out for that. Yeah,
Yeah.
keep it posted if you can.
Yeah, for sure.
I can follow up on that briefly. The California market, I mean, we explored that for our place, and right now it's pretty onerous. And so the idea would be in Oregon, in their failed clean energy jobs bill, we put a verbiage in to make a carbon market that simulated California's, but not as onerous as far as the accounting, the carbon accounting and all that. I mean, it was just be so expensive. You couldn't enroll small landowners, which is the whole point of what we're trying to do here, since the majority of landowners in Clackamas County own less than, 49 acres. And the carbon market was generally set at about 200 acres. So it really limits, the common man. And so the whole idea would be to open this up. And so I think that would be something really beneficial, if we could do that.
All right, well, thank you so much for that presentation, Maddie. It was really informative. That's a great resource for us.
You're welcome. Thank you, Gail. Thanks, everybody.
Yeah, and we'll definitely keep that in mind.